Hello and welcome to Visa and Immigration Weekly, your essential explainer for the Bay Area's Indian community. On this August 12th edition, 4 stories you need to know. USCIS has finalized how a child's age is calculated under the Child Status Protection Act, and there's an effective date you must mark on your calendar. The State Department's September 2025 Visa Bulletin is out with zero forward movement, and it warns that some employment-based categories could hit their annual caps before the fiscal year ends. Locally, the Indian Consulate in San Francisco has shifted most miscellaneous consular and attestation services to VFS Global as of August 1st. And USCIS just issued guidance tightening screening on family-based petitions, which likely means more interviews and longer timelines. Here's what it all means and what to do next.
Let's get straight to our top story. For thousands of Indian families navigating the employment-based backlog, the biggest fear is a child aging out, turning 21 before a green card is approved and losing derivative eligibility. A derivative is a spouse or unmarried child included on the principal applicant's case. The Child Status Protection Act, or CSPA, was created to offset bureaucratic delays by freezing a child's age at a specific milestone. But exactly which milestone has been a moving target? USCIS has now locked in that milestone. Announced on August 8, 2025, and effective for requests filed on or after August 15, 2025, USCIS will calculate CSPA age using the State Department Visa Bulletin's Final Action Dates chart, the column that controls when a green card can actually be approved. That aligns USCIS with the Department of State and clarifies that the Dates for Filing, or DFF chart, used only to allow earlier filing, does not control CSPA age going forward. There's a transition. If your adjustment of status application was pending with USCIS on or before August 15, 2025, USCIS will continue to apply the earlier February 14, 2023 policy that many families used when deciding to file. Why this matters? It creates a predictable, universal trigger. Your child's age can be locked in based on a simple formula: their biological age when a visa becomes available, minus the time the underlying petition was pending. Under this new rule, a visa is available when your priority date, your place in the green card line, is current on the Final Action Dates chart. However, to actually lock in that age, you must take a critical step. The child must seek to acquire permanent residence within 1 year of that date. This usually means filing Form I-485 for adjustment of status or paying the immigrant visa fee abroad. A quick example. If your child's biological age is 21 years 4 months when your priority date hits FAD, but your I-140 was pending 7 months, your child's CSPA age would be 20 years 9 months, still a child. The key is timing plus paperwork readiness. Practical steps this week. Track the Final Action Dates chart monthly. The Visa Bulletin usually posts mid-month. Set reminders. If your date is close, organize civil documents, birth certificates, translations, and medicals so you can file quickly and clearly document seeking to acquire within a year. Ask your attorney to provide a written CSPA age calculation and revisit it as the bulletin changes. If your I-485 was pending with USCIS on or before August 15, 2025, confirm with counsel whether the transitional policy helps you. Bottom line, this doesn't speed up the backlog, but it provides a firm, predictable rule for families to plan around, especially critical for those with teens approaching 21.
With that foundation, let's turn to the September 2025 Visa Bulletin. And it's a tough read for many. The State Department left employment-based cutoff dates unchanged across the board for September. For India, the employment-based categories EB1, EB2, and EB3 show no forward movement. There's also a fiscal year warning attached. The State Department says several employment-based categories are on track to hit their annual numerical limits before the fiscal year ends on September 30th. When a category reaches its cap, it can be made unavailable for the remainder of the fiscal year, meaning no visas can be issued and even approvable cases can't be finalized until numbers reset on October 1st. We've already seen turbulence this summer, including retrogression, cutoff dates moving backward, in some worldwide categories and a later course correction in others, as agencies tried to manage number use. What this means for you: adjustment of status, getting your green card inside the United States. USCIS has confirmed it will use the final action dates chart for employment-based filings in September. If you're current under FAD, assemble complete packets, medical exams, job verification, and fees so you can file without gaps. If you're not current, plan for the long haul. Keep your work and travel permits, EAD/AP, on a rolling renewal schedule. Also, track your AC-21 portability eligibility, which offers job change flexibility after your adjustment application has been pending for 180 days. For those with children approaching 21, this bulletin underscores the importance of the CSPA rule change we just discussed. Your trigger is the final action dates chart.
We'll be watching for any late August changes or unavailable flags as agencies balance the last visa numbers of fiscal year 2025. Next, a local update for Bay Area viewers who use the Consulate General of India, San Francisco. Effective August 1st, the consulate has transitioned most miscellaneous/attestation services, think power of attorney, document attestation, NRI certificates, life event certificates, and more, to its service partner, VFS Global. This means you must now start these applications for things like a power of attorney or document attestation through the VFS Global portal, not by contacting the consulate directly. Two key points many miss. Do not mail new miscellaneous/attestation applications to the consulate, route them via VFS. This aligns these services with the passport, OCI, visa, renunciation, and PCC processing VFS already handles. Limited exceptions remain at the consulate for urgent and specialized matters like life certificates and certain death/transport of remains attestations. Always check the latest checklist before you book. What you should do now: start on the VFS Global portal, pick the specific service, download the latest checklist, and book your slot if an appointment is required. Power of attorney applicants follow the VFS/CGI checklist precisely. Submit the original notarized or apostilled POA, an apostille is an international certification of a notarized document, and any required witness or notary documentation as specified. Missing notarizations or supporting IDs are frequent rejection points. Bring photocopies. Many services require an extra copy for consular records. If you plan to mail documents to VFS, use a trackable courier and include a prepaid return label exactly as instructed. This shift is meant to standardize intake and reduce email back and forth with the consulate. If you started an application directly with the consulate before August 1st, follow any transition instructions you've received and double-check whether you should resubmit via VFS to avoid delays. Finally, for those sponsoring relatives for a green card, USCIS issued policy guidance effective August 1st, clarifying requirements and enhancing screening and vetting for family-based petitions, especially Form I-130, that petition a United States citizen or permanent resident files to classify a relative for a green card. The goal is to combat fraud and ensure relationships are genuine. In practice, this may mean more interview notices in some cases. Impact differs by category. Immediate relatives of United States citizens aren't subject to visa number backlogs, but they will still see the enhanced vetting. Family preference categories face both the vetting and the usual wait for a visa number. Highlights to know. Interviews. USCIS clarifies triggers that make an in-person interview more likely. gaps in documentation, conflicting records, prior immigration issues, or suspicion of fraud. Multiple petitions. Officers now have clearer rules when more than one I-130 exists for the same beneficiary, which should reduce inconsistent outcomes. Routing and status. The guidance explains when approved petitions are sent to the National Visa Center, NVC, which handles consular processing, versus retained for adjustment of status, green card processing inside the United States, and reminds applicants that approval of an I-130 does not confer legal status. Direct filing abroad. USCIS narrows scenarios where a United States citizen can file an I-130 directly with the Department of State, DOS, primarily emergencies, military cases, or certain government personnel overseas. Enforcement note. USCIS reiterates that if a beneficiary, otherwise removable, issuance of a Notice to Appear, NTA, the charging document that starts removal proceedings, is possible. A pending or approved petition isn't protection by itself. Action items for families. Front-load evidence of a bona fide relationship. Joint leases or mortgages, taxes, financial commingling, photos tied to verifiable events, travel history, and affidavits from people who know you both. Be consistent across forms I-130, I-485, I-864, the Affidavit of Support, and with prior visas or entries. Small discrepancies can trigger interviews or RFEs, requests for evidence. Build time into your plans. With enhanced vetting, expect more interviews and RFEs, and respond completely and on time.
So what's on the horizon? Two things. First, watch mid-September for the October Visa Bulletin, the first of the new fiscal year. That's when visa numbers reset, and we'll learn whether employment-based categories reopen or move forward after any late September unavailable periods. Second, we'll track how the new family-based screening guidance plays out in practice. Are interviews and RFEs rising, and by how much? We'll have updates as soon as they drop, plus a downloadable CSPA checklist to help you calculate timelines under the new Final Action Date rule. Thanks for watching Visa and Immigration Weekly. We'll see you next week with the latest news and practical guidance to help you navigate your immigration journey. Have a good week.